Good morning, Kathleen. Oh, she's still connecting. Caroline,
Good morning.
can you hear me? Good morning.
Morning.
I think Kathleen is still connecting to there she is, okay.
Albert McCagg here.
Good morning, Judge.
Kathleen, you're on mute. Kathleen, can you hear me? There you
Good morning. I can now. Well, I could hear you. I'm just off mute now.
All right, Ms. Anderson, Albert McCagg here. Good seeing you this morning.
Same here, Your Honor.
And I see we have Mr. Goff is observing this morning.
Yes, sir.
Will Ms. Robinson be joining us?
I thought she was, but I don't see her. And so there might have been a miscommunication on our end. I told her it was optional, that she wouldn't be required for a status hearing. So,
well, if you want us to take a minute and let you find out whether she's trying to get on, I don't mind
okay.
borrowing a minute to do that.
Let me see.
Good morning, Jennifer.
Good morning.
Good morning,
I was on
Haley.
mute.
Good morning.
Haley, do you have good communications with both parties at this point?
Yes, sir.
Thank you.
We can just start, Judge. I don't want to hold everybody up.
All right. Well, then court will come to order. This is cause number 10-14323 in the matter of the marriage of Charles Hollis Goff and Laura Lee Goff Robinson. This is a status hearing. This hearing is being conducted on the Zoom teleconference application. It is also for purposes of the open court doctrine being broadcast live on the court's YouTube channel. The official record for this is being taken down by Ms. Haley Steigler, and that will be the official record for these proceedings today. I am Albert McCagg. I am a senior district judge and have been assigned to sit on this case by the regional presiding judge, Judge Colin Underwood. Well, counsel, if you would, we'll start out with Ms. McClellan and who you represent, and then we'll go to Ms. Anderson so we get the complete record.
Yes, Judge. Caroline McClyman. I represent Laura Robinson, which was formerly Laura Goff.
Your Honor, Kathleen Anderson on behalf of Charlie Goff. Mr. Goff, I think we have so many pleadings and they've gone back and forth so many times. I think they're both petitioners, they're both movements or counters. So I can't exactly tell you. I guess our position at this point is we're petitioner.
All right. Well, what I have, and I would like for you both to supplement this, I currently see that we have a motion from Ms. McClellan for judgment non pro tonque. We have a first amended motion for enforcement, and we have a counter petition to modify parent-child relationship. Then from Mr. Goff and through Ms. Anderson, we have the response to the motion for judgment non pro tonque, a second amended answer to motion for enforcement, a first amended objection to the notices of child support liens and such, and a first amended motion to terminate withholding orders. Ms. McClellan, what other items do you believe we have currently pending?
There is modifications that Mr. Goff filed back in 2015 that are still pending. I think there was a third amended motion to modify that's on file from either 2015 or 16, Judge. I actually just learned this evening that there was a motion to compel that was on file previously, and there was an order on that in 2015. And I believe that my office is going to have to file something with respect to that if Ms. Anderson and I cannot resolve that issue. But as of right now, I believe there are just amended petitions to modify. The last one that I'm aware of was filed October 31st, 2016 by Mr. Goff.
Ms. Anderson, your supplements, if any?
Your Honor, I was surprised to see that Ms. McClyman forwarded you as I stated, we've had so many pleadings going back and forth. I was surprised Ms. McClyman forwarded you her counter petition to modify parent-child relationship. I guess I'm under the misimpression that request for relief was no longer pertinent. If she's going to pursue that at this late date with this child turning 19 next month, then I'll ask the court to hear my motion that involved our requested relief is that you consider what each party should pay towards this adult child's vision expenses. So again, if Ms. McClyman is going to persist with or proceed with her counter petition to modify, then we'll also bring up the issues regarding payment for Preston's vision expenses. But I really felt like those were moot.
I can explain what our position is as to why they're not, if you'd like to hear that, Judge.
Well, and since we're in the status, it may help just to iron out any issues. We'll probably not do any ruling on it, but at least we can have a discussion.
For context purposes, the reason we're asking to move forward on that, we recognize that Preston is about to turn 19. He's about to graduate high school, I think this week. But we've asked for child support to be modified, and it was a retroactive request to our pleading and when it was filed. And Ms. Anderson, on behalf of Mr. Goff, has asserted that child support should have terminated when the eldest child emancipated and enlisted in the military. And so if the court did find that, we would want the court to rule that child support should have been reinstated based on our counter petition. And so that's why we're going to leave that pleading active. And we would only ask the court to rule on it depending on how the court rules on our motion for judgment nunc pro tunc and with respect to the order to terminate the child support obligation.
Well, in looking at what we have and just hearing the discussion between the two of you, it looks like we have what I will call a hierarchy of pleadings where there may be a couple of issues that we need to try to get to fairly quickly, see if we can resolve those and then set perhaps I'll call them either less urgent or more complex issues for a bit further down the line. Is that something that you would both be amenable to?
Yes, sir.
Yes, Judge.
All right. Well, then I think that's probably what we will look at doing. And in doing that, that would probably give us an opportunity to get some things moving and try to get some portions of this case done. It looks like to me, and of course, we're in a discussion mode here, so these are not directed. These are just discussions, that the objections and notices on child support liens and the motions to terminate withholdings kind of go hand in hand with the motion for judgment nunc pro tunc, because if we don't get the nunc pro tunc ruling, then we're not going to know exactly what we're dealing with for all subsequent motions. Would that be something that you both concur with?
I do agree with that, Your Honor.
I would agree.
All right. And by doing that, then we can look later for the more complex issue of the enforcement, what's been paid, what hasn't, and what wouldn't necessarily come about for being paid. So I think that's probably what we will do, is we'll look for a date in the relatively near term for those more urgent matters and get those set. And then I think we can probably, just looking at those, certainly a half day, but perhaps more time than that. I don't know. It just depends on your witnesses. Those look more like legal issues as opposed to very many witness issues.
Yeah, I supplemented. Apparently, discovery had not been supplemented since 2015. So I took the opportunity to get that to Ms. Anderson only last night. So I know she hasn't had probably a chance to look at that. And I did designate the prior attorneys in the case with respect to the clerical error issue. And so I would just have probably their testimony as well as my clients on that. So I think half a day wouldn't be an issue.
Your Honor, may I respond? Ms. McClyman and I have reached out on numerous occasions regarding the procedural aspect of where we are on discovery. And I have not, we hadn't really resolved where we were. I did supplement. So I've been involved in this case, Your Honor, since 2016. The discovery requests that were operative dated back to prior to my substitution in of December 3rd, 2016. The original request for discovery, I know from Mr. Goff, because there's been numerous attorneys, but date back from Mr. Goff in January of 2015. Mr. Goff has actually supplemented, we did our fourth supplement of discovery actually in March. So he's been keeping up to some degree with these original requests. I did raise the issue with Ms. McClyman, and that's why I'm, addressing the court on this matter. Where are we at on discovery? Because I need updates, and we hadn't ironed that out. And then what I received yesterday were her responses. But in all candidness, Your Honor, I'm afraid it's possible the original requests are outdated. So though I appreciate her responding, back in 2015, there were other issues than there are in 2021. And so I had also requested Ms. McClyman to provide me certain information that's relevant to the current issues. I haven't had a chance, as Ms. McClyman said, these came in last night at 11 o'clock. I haven't had a chance to look at them. Ms. McClyman asked me, just this week, she's asked me to supplement Mr. Goff's responses in a certain timeline, involving, a certain timeline. So we are not on the same page right now, but I believe that we can get on the same page. It may involve some back and forth, and we may need your assistance, Your Honor. In other words, we may need a pretrial on discovery. I don't think so, but it's possible. We may have some disagreements on what each attorney is requesting and why, just because these discovery requests date back to 2015. And Ms. McClyman's been on the case since late last fall. And so I would just ask the court to maybe consider providing us a pretrial regarding any discovery issues in the event, or just be aware that we may need it.
I'm anticipating that that's probably going to be likely needed, Judge. I did get on this case in October, but then I had a baby like immediately thereafter, so I was gone for a little bit. So I apologize for slowing this up for everybody. But what we finally got a box from my client's former attorney who retired, and it has bare bones with respect to discovery. And what I learned and what I expressed to Ms. Anderson was that there was an order for Mr. Goff to produce documents. Mr. Keinert had filed a motion back in 2015, and the date that Mr. Goff was required to supplement and turn over the documents is the same date that Mr. Jenkins, his former lawyer, got off the case. And so I have notified Ms. Anderson that I don't have any of the responsive documents, and it included income information that would be relevant. We are going to need Mr. Goff's income information for child support purposes. And so I'd like to hope that we can work that out. And I told Ms. Anderson, I don't need what was going on back in 15. I need like the last 2 years of income information if we're going to have my counter petition heard, if the child support matter is stricken against our position. So it may be that it goes away, the discovery issue, because you grant our judgment for motion I'm sorry, judgment for non-protunct. And if you grant that, then I don't need Mr. Goff's income information or his bank statements because child support is what it was. But if you do grant, if you decline to grant our request, then I would need it for our counter petition. I hope that clarifies that issue.
I think it
Your
does.
Honor,
Ms. Anderson, go ahead.
Your Honor, I know Ms. McClyman mentioned in an email yesterday afternoon about that 2015 order. So there were Mr. Keinart and Mr. Jenkins back in 2015 were discussing what was Mr. Keinart had some requests, and because Mr. Jenkins was getting off the case, in the abundance of caution to make sure there was no confusion, since Mr. Goff didn't have an attorney for a short period of time, it was put in writing in an order. However, it was very narrow. It was just a few items. That was a year before first of all, I do know that Mr. Goff supplemented after that, but then when I came in on the case in 2016, those were it was no longer relevant. The parties weren't exchanging information anymore just because the issues didn't require continuing supplementation. A lot of issues were actually resolved by agreement. So it's almost like we're starting over. The bottom line is that's 6 years ago, and I'm afraid those original requests are outdated. But I don't think Ms. McClyman Ms. McClyman and I have been colleagues for a long time, Judge. We do talk, we do confer well. I hope Ms. McClyman shares that representation to you. But if we don't, just because procedurally this has been going on for so long, it would be great to have your input, Judge, as a backup. I think that she thinks we need a hearing. I brought up the request for a possible hearing as a backup. Hopefully we won't need it.
Well, looking at where we are, and of course, I don't know your current schedule, but if and I were to say, well, all right, let's resolve what we can in the way of discovery disputes within the next 30 days, so that we'll have a timeline that we're all working on, knowing that you both have busy schedules otherwise. Is it 30 days to at least settle where you are with discovery? Is that realistic?
Absolutely.
Yes, sir.
Well, all right. Well, let's just say that as within 30 days that the parties will have updated discovery and supplemented responses to discovery that is currently pending, and identified any further discovery that may be needed. And at the end of that 30 days, if you need some assistance, either through a motion to compel, motion to clarify, whatever it may be, then certainly get with Jennifer and we'll set that up and get you a hearing as quickly as we can.
Yes, sir.
And at this point, Jennifer, we're not actually setting a date for that. That's just simply going to be a review date that we'll put into the docket notes.
Okay, yes, sir.
And that really tells me quite a bit about what we want to do, because I think once we get the discovery done, then we'll know where we're going to go with these, what I'm going to call the primary or first in order matters that we have to hear. Ms. McClyman, is it McClyman or McClyman?
It's McClyman.
McClyman. You had mentioned possibly having the other attorneys that had been on the case. Will they be coming in as expert attorneys, or will they be coming in as fact witnesses?
I designated Mr. Jenkins as a fact witness because he was Mr. Goff's attorney, and then I designated Mr. Keinart as an expert as well as a fact witness, just out of an abundance of caution.
All right. I just wanted to be sure that we had any notices and designations that are required by the rules.
And in fairness, he might not be happy with me about it, but I also listed Judge Eskew as a fact witness just because he knows what he did at that hearing, and I didn't know if you might want to hear from him. I'm sure he does not like being dragged into this, but I didn't know if you would want that information since you are taking over and you're not necessarily in his mind, and you don't. I looked at his docket sheet. I went and got a copy of it. It's fairly brief, and so out of an abundance of caution, I did designate Judge Eskew.
Well, and an issue that it will certainly need to be briefed, because I have encountered this before on a couple of matters, is are we inside the judicial discretion that he would have? Because I know that there's some case law out there that we do not get into the thought processes behind the judicial decisions. So we may need a little briefing on that before we get into the meat of that particular issue.
And Your Honor, may I respond to that just briefly, because I know that that you'll direct us as to what you need or want us to provide you on every issue. But what Ms. McClyman, this is the first I've heard of it, so I'm just, it's very spontaneous, my thought process, because I did just receive this last night at 10:55. But first of all, I don't believe we're going to be disputing that the parties agreed to deviate from the guidelines. Ms. McClyman's calling it contractual child support. It's not their agreement deviated from the guidelines. Much of their decision making in that regard took place in mediation, which is not admissible. That information is not admissible. And also, this was back in 2012. And finally, Judge Eskew actually recused himself from this case. I don't know that, it seems like it's opening up a little bit of a can of worms, but, and what you stated, Judge, is, that we may need to brief it. I'm pretty sure that Ms. McClyman's position really, it cannot be that broad. It's what the record shows, not what is testified thereafter.
Just be a question to Judge Eskew whether he provided any of the language or whether that was solely him entering in an agreed to decree. And I'm going to reach out to the court reporter, Ms. Freeman, who's since retired, to see if she has the transcript for the prove up. If it's not available, then the only question I would have for Judge Eskew is, did you just enter what was presented to you based on a prove up? That would be my only question really for him.
And that's something that, yes, we can certainly get more into the briefing and legal issues of that. It's good that we are all aware of it so we can have that at least in the back of our minds, if not in the forefront of what we're going to be looking at. All right. Are there any other expert designations that are we bringing in forensic accounting or any? Are we strictly relying on the child support record?
Just
Your Honor, when I update my discovery, some of my witnesses regarding, from the education field may be lay, they may be designated as experts, both in academia and homeschooling and secondary education. But I appreciate the 30 days that you gave us, because I'm going to need it. I am going to need it because the theories are developing, almost on a monthly basis. So in terms of what's being pled, I may be designating some experts in academia, secondary, homeschooling.
All right. Well, I think perhaps at this point, let's get through this 30 days. And as you analyze where you are with your discovery, determine if there's anything else that needs to be filed. It looks to me like that by roughly the end of June, 1st of July, we may be ready for either another status conference or a partial pre-trial meeting on the issues that we're going to address first. It's kind of what it looks like to me. Of course, we'll stay in the loop with both one another and with Jennifer to make sure that we can do that. I will tell you that I start a non-death capital jury trial June 21st. It's expected to last 2 weeks. So my availability may be somewhat limited, even though I might be able to do an hour or two here and there.
Your Honor, I have a jury trial. It may be the first jury trial that we do in Bastrop County since the pandemic began. That is scheduled. I don't see any reason why it wouldn't proceed unless there's some exceptional circumstances from one of the attorneys or witnesses, but it's to begin June 20th. And it will be a week long. I have no doubt it'll be a week long. It is a civil case, Your Honor. It's a highly contested divorce with causes of action. So it's going to be a week long. So I would ask that if we're going to, I guess I'm probably on your schedule where I would be ready for any type of hearing you'd like to set, maybe by the end of the first week of July, first week of July, in that, after 4th of July.
Yeah.
Okay. Just so everybody's aware, sorry, the only summer break I'm taking, I'm going to be out of the country July 12th through the 16th.
July 12th through 16, you said, Jennifer?
That's Caroline. Yes, Judge.
Carol, I'm sorry.
No, you're fine. I have a 3-day long docket setting in Travis County that starts on July 19th with Mr. Gilbreth. But I'm available. Oh, I say that. I'm supposed to go to mediation in a case that's in front of County Court at Law on June 21st and 22nd. So I'm not trying to be difficult. If there's any way we can do it that first week of July, that would be amazing. But if you're not done with your trial, Judge, then obviously that blows that out of the water.
I should be through with my trial by the week of the 6th. The 5th is the observed July mistake. So perhaps, Jennifer, if you'll work with the attorneys for something during the week of 6, 7, 8, 9 July.
We are completely open the afternoon of July 1st and July 8th, the afternoon, and then all day July 9th. I'm sorry, I didn't hear how long the hearing would be.
Well, let's leave this one at a half day because this is going to be, well, I don't anticipate us being ready to go forward with these issues. We're more or less trying to make sure that the discovery and designations of witnesses have been brought up to speed before we get into that. So let's leave it at a half day.
Okay. So on the 8th, the afternoon of the 8th, Judge?
Or July 9th.
Yeah, I'm good on either one of those. Ms. Anderson, how do you look?
Same, Your Honor, I'm available.
All right, let's set it for 1:30 p.m. on July 8th. Haley, are you available? You can nod or.
Yes, sir.
Okay, thank you. Well, then.
Will that be Zoom or would that be in person?
You know, it's likely to be in person by that time. I'm willing to accommodate the attorneys if travel becomes somewhat of an issue. But I'm anticipating that the Supreme Court is about to release most of the gates on us. So we'll just tentatively say in person, but I can be persuaded by sound reason and logic to change that.
I'm looking forward to in-person trials again, Your Honor. But of course, if anybody had some impediment, you're not going to hear me objecting, but I certainly hope we can meet in person. And Your Honor, for clarification, this is going to be basically a pretrial involving any discovery issues. And on this date, you'll also direct us when you'll hear our live pleadings?
Yes. And the reason that I want to do it in these 2 stages is depending on the complexity of the then current condition of the live pleadings is determine how far out we may need to give you in order to get ready to go on it.
Right.
Sounds great. Thank you, Judge.
Well then, Ms. McClyman, anything further that we need to discuss today?
No, Judge, that's it. Thank you so much.
Very well. And Ms. Anderson?
No, sir. Thank you. Nothing further.
Very well. Jennifer, anything else you need to point out?
No, sir. I've got it set for July 8th at 1:30.
Sounds very good. Well, I appreciate the courtesies this morning. That does conclude the matter. The hearing is terminated. Therefore, the record is terminated. And we'll be seeing you soon.
Thank you, Your Honor.
Thank you.
Bye-bye.
Jennifer, you just want to hang around just for a minute?
Yes, sir, I will.
All
Okay,
right.
that is, the other person in the hearing is Sharon. She's in our district clerk's office.
Ah, I see. Good. Good morning, Sharon. Did you get what you needed, Jennifer, from all of that?
Yes, sir. Are you going to send me your docket note? I mean, do you want to send some specific docket notes, or you want me just to, how do you want to handle that?
Well, I don't want to complicate what you're doing. Would you mind, once you've done your notes, just email them to me? Let me take a look, and if they look fine, I don't like meddling in other courts' common ways of doing things just because I'm the big dog here. I like to try to keep within the boundaries of what you normally do.
Well, and I was going to ask Sharon, I asked Sharon this morning how the other visiting judges are handling it. Are they doing written notes or whatever? But Judge Eskew, has his laptop and he just enters his notes in the system based off the rulings. But I can just type up something and forward it to you, and you say it's okay. I can put it in the notes, or we have a blank docket sheet if you want to print it out and
No,
write it and back.
I've got the
Okay.
time this morning, and what I'll do is I will prepare my docket sheet or docket notes to you, and I will send them directly to you, Jennifer, and then you don't have to try to create what you think I think.
Thank you. I'll be
All right.
looking for that. Okay, thank you, Judge.
Appreciate it very much. We'll be leaving now. Look forward to seeing you, and tell Gary hello.
I will. We sure will. Thank you.
All right.
It was so nice to meet you, Judge.
And you too. Thank you, Jennifer.
Bye-bye. Yes, sir.